Oh, good. We're live. This is Senate Judiciary Committee, February, whatever date, 18th, 2021. We're first taking up this morning S11, an act relating to prohibiting robocalls. And we have a redraft of the bill, and we have David Hall from Legislative Counsel, Clay Purvis from the Department of Public Service, and Chris Delia representing the Vermont banker as witnesses on the bill. So, David, maybe you could walk us through the redraft, and then we could take Clay and Chris if they have any.
Sure.
Committee members, by the way. Too. Senator Benning is not here right now because he is waiting for Comcast to fix his internet. Maybe he'll need help from the Department of Public Service to do that, but we will hang in there and see if he joins us soon.
Would you like me to share the draft on the screen, Senator?
Yes, please. Yeah, okay. Please.
I'll do that. Let's see. I think you want to see this. Are you seeing the? Are you seeing a judiciary amendment?
Yeah.
Oh, good. That's better than my emails. I see Senator Benning is waiting in the waiting room.
Oh.
Okay, there he is.
Please feel free to go ahead. Oh, Senator Benning is with us?
Yeah, he just came in.
Wow. The magic of Comcast. Go ahead, David, please.
All right. So good morning, David Hall, Legislative Counsel. What you have on your screen, what I emailed to you last night, is a strike all amendment to S11, an act relating to prohibiting robocalls. And, gosh, the adage about simple little bills in this building is applicable here. Perhaps I have not sufficiently set the stage for how complicated this is in the background. I don't know. There are multiple federal statutes and multiple federal regulatory agencies that have authority in this area of the law. And the Telephone Consumer Protection Act in particular is sort of notoriously complicated and unintelligible. There's just a maze of cross-references and nuances that make compliance with this law really challenging. And I recognize that. And I say all this as preface here because what I want you to understand is the way I've prepared this draft and this bill is to try to have a law that is functional at the state level, but also helps people to understand, what they can and cannot do. And after redrafting this many times, and at one point I was trying to pull in all the different pieces of federal regulations, you were going to end up with 20 pages of legislation. I took a step back and thought I would try this approach, which you have in front of you, which is still creating a state cause of action that is tied to and coextensive with a federal law, but has this new piece to it at the beginning here to just signal to the world exactly, in plain, a little bit more plain language, what you're trying to do. I did have correspondence from Chris on particular issues, and I emailed you about those last night. I'm happy to take questions if you have, but let me just look at the language with you and take it from there. So again, this would be adding a new section in Title IX. Right now, in the area of the Consumer Protection Act, we have a series of sections that deal with telemarketing, telephone solicitations. We require telemarketers to register with the state. We have imposed a requirement to provide accurate caller ID information. There's already things on the books in this sphere, and we're adding to that area. In A here, that's a statement of intent of the General Assembly in adopting this section to do two things. One, to create a state law prohibition on the use of automatic telephone dialing systems and on the placement of robocalls to Vermont consumers that is coextensive with the federal limitations created in the TCPA and the TCF-APA. I do use the term robocalls in this intent section, but I'm going to address that in a moment. Under A2 here, to continue to permit certain robocalls to the extent they are allowed under federal law, including calls made for an emergency purpose, calls made with a prior express written consent of the called party, calls conveying messages that are purely informational, calls concerning the collection of a debt, but not including calls that attempt to sell consumer services to reduce debt, political calls, calls from healthcare providers, and messages from charities provided, blah, blah, blah. If it comes from a hired person, call can only go to members or prior donors. Provided further, callers have to have an automated option automated option. I'll have to look at this. That's a mistake, but I did add the definition here of automatic telephone dialing system. This comes directly from 47 USC 227, the TCPA.
Can I break in just a second to ask a question in G on line 3?
Please.
Charities, would that include things like the Vermont Sheriff's Association, who hire out of state, I don't know what you call them, people to raise money for them, and then they give you calls saying, you know, your local sheriff needs you, and you realize it's from some other state. I've had that from a number of those law enforcement associations, and sometimes I don't even think it's our state sheriff's association.
I don't think that our local people hire them. I think they do it on their own.
Senator, the association years ago hired fundraisers that charged them 90% administrative fee. The association got 10. The association members from the Vermont Sheriff's Association met in Montreal and hired this guy at some convention that was held. And we actually had to subpoena the individual from Kansas City to get him to testify. Once we got subpoena power, he agreed to testify, and it was shocking information. And we changed some of the laws regarding notification of the administrative amounts that were involved in the charitable request. So Vermont, now this was years ago, and maybe they don't hire anybody anymore. But I certainly have received robocalls from some law enforcement organizations. Got one the other day.
Well, so it's a good question. The answer is yes. There's some nuance, of course. I mean, calls from nonprofit organizations are generally exempted from the prohibitions. There are tighter rules if a nonprofit organization hires a third-party caller on their behalf. so the short answer is generally yes, those calls are allowed on behalf of nonprofits, though there are some tighter restrictions, some more nuance on whether they're, if it's actually the organization or somebody they hired, and whether they're asking for money, which is a telephone solicitation, which has a whole additional layer of regulations on when those calls can occur, how you opt out of them, those types of things.
Well, could we add a line to this that they're required to tell us the amount of money or the percentage that goes to administration for the charity?
That's actually a First Amendment violation.
Well, that's BS. Pardon my French. That's absolute craziness. I don't understand how that would be a First Amendment violation, David.
You can still look that up on the internet, right? I mean, I've looked up quite a few of them.
Yeah.
Well, then why can't we require them to tell it if we can look it up on the internet? I think state law requires them to do that.
It's compelled speech. There have been a number of cases that have challenged different state requirements that force solicitors to, basically say more than they otherwise would relating to the activities. I mean, it depends. It's not an easy answer or analysis.
I just want them to admit that they're robbing people.
Can I?
And that the charities, frankly, are a huge percentage of what they're asking for goes to administration from the company that they hired to perform the duty. And I don't see that as a free speech issue. I see that as a transparency issue.
I can put that in if you'd like.
Hey, David.
Yes, sir.
David, you have a Scrivener's error on line 5.
Yeah, this hasn't been through editing yet. I'll certainly check it if it moves forward.
Okay.
Well, I'd like to consider that. If the committee doesn't want to do it, let's live with that. But I'd like the arguments against being transparent. And I think it's important for people to understand that many of these charitable organizations, the fundraiser gets a huge percentage of the money that people are donating. For example, you donate $10, you might find that $8 is going to the administration for the fundraiser, and that a very small percentage of your money is going to the charity. And I know that we are able to do that in other places. So I'm not sure why we wouldn't be able to require that on the robocall.
May I ask a question about that? So this says the call comes from a person whom the charity hires to make the call on the charity's behalf. So if United Way of Chittenden County hires Joe Schmo to make the calls, does Joe Schmo have to say what his salary is that he's getting for making these calls? Because he is making the call they have hired him to make the call on the charity's behalf.
Are you asking me if this requires somebody to disclose their salary?
Well, it says if Senator Sears puts that in, that they have to disclose how much goes to the administration, and I suspect that the administration would be the salary of the person making the call. If they hire somebody to make the call, that's what it says.
No, you're saying things that I didn't say. I said the percentage of the donation that would go to administration of the fundraising. So it would not be Joe Schmo's salary. It would be of the amount that's donated, 90% goes to the cost of raising the funds, or 10%, which would make me more comfortable with that charity. I am very uncomfortable giving money to charities that have hired out-of-state fundraisers that you have a huge percentage going to their fundraising effort rather than to the actual charity that you think you're donating to.
I agree with that. And my solution to that is to not ever give to anybody except directly to the charity.
Well, you can't do it because this
Yes,
is
I
how
can.
they operate. Well, I made a proposal, Senator. If you
Okay.
don't like it, vote no. I don't.
Yeah.
I just,
Okay.
I'm just saying that I think out of transparency that that we should know when we're getting scammed. And to me, and when 90% of the funds that are donated to this charity go to administration or the fundraising effort itself, then that's a scam. It's not going to the charity.
So I just want to, again, state for the record that the U.S. Supreme Court has struck down several laws that do that, including
Well-
Riley versus National Federation for the Blind of North Carolina in 1988.
Well, I'll agree with Senator White then. We probably shouldn't give to charities that we don't know if we can't give directly to the charity. If it's been struck down by the United States Supreme Court, that's, I just think that's, maybe I think it's a scam when they take a huge percentage of the fundraising.
So, it may be possible, I'd have to look further into it. The speech issue is the speech issue, but the regulatory issue of limiting how much, people could take as a percentage as a state police power may be permissible. It would only work probably if, it was pretty clear that the business doing the solicitation was also in Vermont.
No, we can't get the business doing the solicitation, to be honest.
Anyway, Move
ahead. That's fine. Move ahead, please.
Sure. So the definition, again, is from the federal law. It's for automatic telephone dialing system. You'll see there's not a definition of robocall. And as I emailed to you, the federal language that captures it is to use an artificial or pre-recorded voice. And that is consistent across statutes and regulations rather than defining robocall. At this point, the term robocall, there's a lot of writing in the FCC report about how the term has sort of become this all-encompassing, code for any calls we find undesirable. But there's no single definition, and truthfully, there's different standards for whether it goes to a landline or a cell phone or a pager or different things. There's different standards for if it's a transmission to a fax machine, etc. So I would be reluctant to try to make up some definition as a matter of this state law when there isn't one for the federal law, and create a divergence rather than continuing to use the same phraseology that the federal statutes use, which is artificial or pre-recorded voice. So that's my reasoning. You guys are, of course, welcome to do otherwise.
I suspect you're right, David.
But that's why that's not there. So then the rest of it looks basically the same. Again, in C here, the prohibition is specific that it's both on automatic telephone dialing systems and artificial or pre-recorded voices. I mean, those are often used together, but not always. And there are some separate regulations on the auto dialing system. For instance, you can't use one to tie up multiple lines of a single source. So if a business had, several phone lines, you're not allowed to use an auto dialing system to tie up all of their numbers. So that's one divergence, but often they're used together. There's still a civil violation. there have been questions raised about the criminal penalties, which are still here until you tell me to take them out. So again, that is not more than 90 days or $1,000 per violation or both, and each call is a separate violation. And then, of course, the last piece we already looked at together, which was also in the bill from last year, is this directive to the AG's office to work with other state and federal entities to identify these callers and, to the extent they can, bring in enforcement action.
Yeah. What is the concern about the criminal penalties?
I don't know the specific concern. People just said they don't like them. At least in the email I received.
Okay.
But you guys did reduce that from the bill as originally introduced last year. It had been $10,000 per violation, and in response to testimony, you reduced it from 10 to 1,000.
Okay. Well, who doesn't like the robocallers? I don't know who they are. So
Sure. So
I can't ask them because they don't answer the phone. It's a pre-recorded message.
Maybe they'll send you a robocall with their objections.
Maybe.
So that's the amendment. There was additional information in the email I sent you last night. I'm happy to answer any questions. I'm also happy to stand aside and yield the floor to whomever else you would like to hear from.
Are there any questions from the committee? Okay. Clay, do you have any comments?
Yeah, hi, thank you for having me today. I'm Clay Purvis with the Department of Public Service. First, I'd like to commend the committee for addressing robocalling. This is an issue we hear from consumers about frequently, both informally and through our CAPI process. It is a difficult issue to handle. I think as David pointed out, enforcement is and continues to be the greatest problem that we're aware of in stopping robocalling. I did put together a short presentation on robocalling, not being really sure where the committee was on the issue, but it sounds like you have come quite a long way on your thinking about the issue. So I don't think the department has any issues with the bill. I think that the bill on balance is good, and I think will be appreciated by Vermonters. With that said, I think that the federal government has long struggled with enforcement, including the FCC, and will continue to struggle. And that the most productive thing I think we've seen in the past couple of years has been the adoption of third-party applications made for consumers to stop robocalling. I think we all have those on our phones now, and those are more helpful than nothing, but certainly still a long way to go to ending robocalls.
Yeah, I don't obviously appreciate that. How many, do you have any estimate of the number of complaints you received, say in a month's time?
So in Vermont, the Attorney General's CAP division probably takes the brunt of the calls from consumers on robocalling. We receive a handful a year, 7 to 8 complaints about robocalling. We do also hear informally from constituents about robocalls. Nationally, though, people are receiving billions of robocalls. The FCC estimated somewhere between around 26 billion robocalls in 2018. So people are getting several of these a day, and the vast majority of people ignore them, but they are annoying and can be quite dangerous, actually.
Beyond being annoying, I don't remember the number from last year, but we had a document that gave us, it seems like somewhere almost 3/4 to 2/3 of the robocalls are scams.
Mhm.
Would that be an accurate comment? Does anybody know?
I believe that's accurate. And where the FCC has really focused its efforts, I mean, as David pointed out, not all robocalls are legal, and it's very hard to kind of weed out robocalls based on content. So they've really focused on spoofing, ID spoofing, which is illegal. I'm sorry, I've
That's
children
okay.
here. Which is illegal, and it is something that the FCC has empowered carriers to work on. A couple of things they've done, they've implemented stir shaken and required carriers to implement this. This is a caller ID authentication standards that have been developed to help ensure that the call that comes up on your ID is legitimate. Other things that they've done, they've empowered or allowed carriers to weed out calls that are coming from unauthorized numbers. So, for instance, numbers that have not been assigned by NAMPA to any provider. They can weed those calls out. So, that's even before the recipient sees that he or she's being called. And those things have helped reduce the number of robocalls. But the unfortunate thing is that these scammers are always one step ahead of the rules and regulations, and they're often operating out of foreign countries. So the ability of the carriers to locate the originating call, and law enforcement to trace the caller's identity is very difficult.
Unbelievable. I mean, it's just a device that I don't know how they do it, but sometimes I've heard of people's own phone numbers are called, or I did get one recently that said it was the state of Vermont on my caller ID, and it was a robocall. So
yeah, I mean, they're getting much more sophisticated, and they can use voice over IP carriers that are hard for the FCC to trace. A lot of these kind of fly-by-night phone companies that offer over-the-top voice service, they don't maintain their records with the FCC. They're really on the fringe, and so it's hard for even the FCC to track these carriers and these callers, but even more difficult for states, I think.
Senator Benning has a comment or question.
Clay, I'm listening to all this, and I'm coming to the conclusion that the only thing this bill will actually do is enable Vermont to prosecute someone who originates a call from Vermont, or enable a private citizen to bring a civil action against somebody who originates a call from Vermont. I don't see this bill as accomplishing anything beyond that. Do you see anything that I'm missing?
I mean, that's a jurisdiction question that I don't think I've thoroughly researched. The federal legislation does empower attorney generals to, or at least my understanding, that attorney generals have authority to prosecute cases under the federal legislation. As far as the civil penalty goes, I don't know to what extent the state can exercise, or the court has jurisdiction over a caller who's operating outside of the state. I mean, obviously the harm is occurring in the state, but I guess I would struggle to, if I were the victim, I think I would struggle to even identify who it is that I would file a civil action against. Finding the identity of these scammers is difficult, and they disappear and reappear as something else overnight. So I think it is going to be a little difficult for victims to take advantage of the civil penalties. With that said, we don't know exactly what amount of the traffic could be in Vermont, and it never hurts to have those safeguards in place just in case.
Okay, thanks.
It potentially could have some impact. I think David Hall has to leave or is that correct, David?
Yes, sir. I do have to run over to Commerce.
Okay. I think we're scheduled to end this. We'll pick up here in the near future with and Chris, Delia, if you have any comments, briefly take them now, or if you want to wait till next time we look at the bill.
Thank you, Mr. Chairman. I'm happy to wait till next time you look at the bill.
Okay, thank you. So we'll come back to Clay and Chris and David. Thank you very much. We'll come back to this in the near future, hopefully in the near future. I think David sure may have heard that question from Senator Benning, and if you could ask I think Charity Clark's been working with us on this bill, but asking anybody in the Consumer Division of the Attorney General's office if you think this bill would do any more than feel good.
I'm happy to pass the question along, Senator.
I'm paraphrasing Senator Benning's comment.
Well, what politician wouldn't want to vote for a robocall bill? That's one way of looking at it. The other question, though, is if the robocalls keep coming, we're going to be looked at as a useless entity. And I don't see the bill itself preventing the robocalls from coming. So I'm a little, I think it was Charity who said it would be nice to have a tool in the toolbox. And I can understand and appreciate that, but unless you've actually got someone in Vermont that you've identified as originating the calls, both the civil and the criminal pursuit are pretty much useless. And I don't know whether or not I would feel good about passing something that doesn't get us anyplace other than to say we passed a bill against robocalls. And I guess I'll leave it at that. I'm struggling with it. If you come up with some other reason why you need to have that tool in the toolbox, let me know and I'll give it some more thought.
We'll get back to you on it.
All right, thank you. Now we'll move on to S45, the probation bill. So if you want to take a 3-minute break to get your orientation reversed from robocalls to probation. Peggy, I don't think you have to go off YouTube. I'm gonna just take a 2 or 3-minute break to stretch my legs and come back to robocalls. So why don't we try to hook back in at 10 past 9, 5 minutes, okay?
Sounds good. Everybody mute.
Well, there we go.
Another day, another dollar.
I was thinking that.
I swear, I went to bed last night. I hadn't left the house. I had only been at my desk and at the kitchen table all day. Hadn't seen my kids. It's just turned into
It is.
I feel like a rat in a cage.
I know.
Just respond.
Yesterday, I was so excited to go out and pull the garbage cans back into the garage. I had something to do outside.
Yeah.
It really is an unbelievable experience.
Yeah, you throw in the frigid cold.
Yep.
Where you don't want to go outside, and it really is 2 months of home confinement.
Yes. Yesterday, my son and I went shopping in the afternoon. That was the highlight of my week.
They could at least give us an ankle bracelet.
Yeah. I'm getting my second shot on the 8th of March, and I'm just hopeful that I heard what the Commissioner of Health said yesterday about, not needing to quarantine if you are after 14 days after the second shot, if you come in contact with somebody who's positive. So I'm feeling that that'd be a good opportunity to take a ride to Montpelier or something. I still can't leave state unless they change their lines, but I haven't even been over to New York, and I think I went to Arlington one day just to drive up there, just to be outside.
Yeah.
It's just been an experience like none other. This session certainly.
Well, one more month, I figure, and then spring will be in the air.
Yep.
It'll warm up into the 40s, and we'll be all set.
Yeah.
So I've been emailing Tim Ash or texting Tim Ash this morning. He was commenting on a bill that's not in our chamber. And I got to use the term jackwagons for the first time.
Remember, we're live.
Yeah. Very useful term.
I don't think that's a curse word. I think that's a.
It is not.
No, I think it's in the dictionary, which was surprising.
It's like Jism Crow.
Yeah.
Yeah.
I had just never used that term before. I thought it was a perfect moment.
I like the term, but I like better when Dick goes into the whole etymology of where it came from and the guy who was on the wagon.
Was that Festus?
Isn't
Who
good
was it?
enough.
No. If you go back to Clint Eastwood in Rawhide,
Okay.
I can't think of his name now, but he was the one that wasn't even
Roddy.
wasn't allowed to drive the chuck wagon. He had to sit on the other seat in the chuck wagon while the other guy drove the chuck wagon, and so he was the jack wagon.
Wasn't it Roddy McDowell?
I think so, yeah. I can't think of the character's name though. Obviously, Clint Eastwood was the lead actor in Rawhide.
So does that make the Senate Clint Eastwood, or what are we in that?
Oh, I think we're Clint Eastwood, and I think the House is clearly the guy who can't ride a horse and is not allowed to drive the truck wagon.
Why do I suspect that next time we get into a conference committee, they're going to play this back for us?
Oh, I don't know. I remember one conference committee, and I said something to Jane Kitchell about why we weren't getting something out of the House, and she said, well, probably they're tired of you calling them jackwagons.
So one of the things that I really love to do is changing the subject a little bit, but speaking of debate and use of words.
By the way, we're live on YouTube.
I know. I love to read Mason's. I
Yeah.
know. And Philip, I have your quote completely highlighted in yellow here and underlined a couple times. But one of the things that Mason says is during debate, no one is to disturb another in a speech by hissing, coughing, or spitting. Just so you know, don't spit during debate.
Well, remember the tedious thing.
Yes, it's right here. An ancient
Yeah,
rule governing debate is that no one is to speak impertinently or beside the question, superfluously or tediously.
Well, I saw Galbraith in the bathroom before that, and he was filibustering, you remember?
Yes.
And I said, look, if you continue to filibuster, I've got this airtight, procedural way to shut you down. And he says, no, there is none. And so then he kept filibustering, and I did it, and he really got mad about that because it became a thing in your district, I guess. People were kidding him about being tedious.
If you remember, what he was doing is he spent about 2.5 hours questioning me on every comma and every period in the difference between the House bill and the Senate bill. And I knew all of them. But yeah, that's when you said he was being tedious. And yeah, it wasn't just that. There was a lot of other things that were issues, but.
And the great thing was, Phil Scott had to choose between either supporting my motion or saying that Galbraith wasn't tedious. And he didn't want to do either one.
Speaking of tedious, we're taking up S45, an act relating to earned discharge from probation. Sometimes we go over bills in a fine-tooth comb and find every dot and every word, but hopefully we won't need to do that today. I think we're getting pretty close. So, Bryn, would you mind going over the latest draft that I believe is posted on our webpage, and it is draft 3.2.
Good thing.
The good news is we've lopped the page off, now 1 of 8 rather than 1 of 9.
Yep. If you're looking for good news.
If we're looking for good news.
So good morning, committee. For the record, Brandon from Legislative Council. And I can share my screen if that's helpful to walk through the few changes that have been made to this new draft 3.2 to S45. Okay, I'll do that. All right, can everybody see? Okay.
Yep. Yeah, that's much better.
Oops.
No, the way you have it right there, that's great.
Okay.
I can actually read it on my screen.
So there are just a few changes made in this version, and you'll see some changes in yellow and some are in green. The green language is recommended language from David Scher from the Attorney General's office. So we'll just go through that too, and then I'm sure he can speak to those provisions.
You're just adding the word thereby to thereby protect the safety of the victim and the community. And
right. So that
anybody with a problem with the thereby?
Nope.
Okay.
Thank you.
So the next change is in section 2. This is the duration of probation, directing the court to dismiss a probationer if certain criteria are met. So remember that this is the language in subdivision B that there's been quite a bit of discussion about. Yep. So this is recommended language from David Scher that the probationer is not substantially in compliance with the conditions of probation that are related to the probationer's rehabilitation or to victim or community safety. So that is one of the criteria that would prohibit the court from discharging a person from probation.
And who determines the substantially?
So that would be up to the court to make that finding.
Okay.
Okay.
Yep.
So now I'm going to jump to section 3. I think we're on page 6 for the next change. And you remember this is the language that directs the department to make a midpoint review of a probationer and recommend that person for discharge if certain criteria are met. And there was quite a bit of discussion about subdivision C. So the criteria here are that the person hasn't violated the conditions in the last 6 months, isn't serving a sentence for certain types of crimes, which you recall include the domestic violence offenses, sexual assault offenses, or lewd and lascivious with a child. So those people, those offenders are carved out. And then C, this language is also recommended by David Scher, has completed any rehabilitative or risk reduction programs, the duration of which are set and knowable at the outset of probation and that are required as a condition of probation. So there's one additional change besides that, and that is down the bottom of section 3 here. And this is the reasonable effort language that we discussed. What does it mean for the prosecutor to make a reasonable effort to notify a victim of any changes in the probation or sentence? So we've put in language there that comes from the expungement chapter, defining.
It looked familiar, that's.
Yep, it should look familiar. So reasonable effort means attempting to contact the victim by first class mail to victim's last known address and by telephone at the last known phone number. And that's it for the changes to this draft.
Good. You want to, David, sure, if you want to lead off with your changes and then we'll hear from others. I think you can take the screen down now. Hope. It is on our webpage. This draft is 2.2, so 3.2, excuse me.
Thank you, Senator. For the record, Assistant Attorney General David Scher. I'll briefly explain a couple of the changes here that we'd suggested, and it's very much in line with what I talked about. I know other witnesses have talked about as well. This notion of having a two-step process, or I should say, we are creating a two-step process. Step 1 is actually later in the bill, so we'll start there on page 6. And the idea here is that step 1, to the greatest extent possible, should be, this is the step where the Department of Corrections makes a decision on sending up a recommendation for discharge up to the court. And to the greatest extent possible, I think that this should really be a predictable, consistent process across the state where there's relatively little discretionary decision-making happening. It's just saying, did you check the boxes or not? And that's the goal of subsection C here on lines 16 through 18. I am very open to other suggestions about language. I'm certainly not attached to the specific text that's there, but what I'm trying to embody with that is this notion that probation programming, where there's a known duration, there's a specific duration that does not that extend forever into the future or depend on performance during the program. And there are a number of programs like that we've talked about. And I'm trying to capture that's those sort of set duration programs like CRASH using that as an example, where it's a known curriculum, it's set, you either finished it or you didn't finish it. That's the type of thing that I'm trying to capture there. Again, I'm very willing to take suggestion if there's a better way to do that. So that's step 1. Let's go up in the bill to step 2, which
David,
is on. Yes, Senator.
I'm sorry, if I could just, I like that language. I think it's better than any we've seen so far. I do still find myself wondering about someone who in good faith would have completed, but it was not offered. So we have had testimony in the past about programs that were necessary for somebody's plan, but they were not offered for various reasons, lack of resources, et cetera, pandemic, whatever it might be. So under this, the commissioner might not send these, these cases forward through no fault of the prospective probationer's own, but just because the system failed them. Is there a way to put in a clause that says if offered or something like that? I mean, I know it takes you down a whole other road, but I just put it out there as a way of saying that there's at least potentially some subset of people who might in every other way satisfy this, but the system didn't provide their programming when it said it would.
I would focus on the word knowable in that case, Senator Baruch. I think it kind of encompasses it, durations which are set and knowable at the outset. So if you thought that this was going to be available, maybe there should be, due to the pandemic, all of this, they couldn't avail themselves of this treatment. Maybe that would allow for the person to seek a modification of the conditions of probation. I don't know. What does knowable mean in that? Is that what that means? We thought that it was going to be available, and then, some circumstance.
Right, I understand what you're saying, Senator. I mean, my intention there was that the knowable was modifying the word duration. So that the duration was known, was a set duration that was known at the beginning, when the condition was assigned. I hear the problem that you're saying. I don't think in candor that this language addresses that problem or solves it. To some degree, I think that would have to be some sort of separate provision if we do want to address it. I also think that, if there is a set condition that somebody's supposed to fulfill, sometimes scheduling means that they may go past the midpoint. But then
and I don't mean to hold up the train, because like I say, I think this language is very good for what we were looking to do. It's just I suppose it's always, no matter what we do, we're going to have the system fail some people by not providing something that they needed at a certain point. Joe has testified that his clients often can't get different resources that are supposed to be provided. When we went to Northwest Correctional, we were told that there were certain programs they couldn't get. But that's a broader failure of the system, and it shouldn't affect this reform going forward. So I'll just note it and say that otherwise I like this language.
Thank you, Senator.
Anything that drives that consistency statewide is going to be helpful. Bill, you've raised an important point, but I do think people can go back for modification of the conditions of probation if something is not available, or if they discover that something else should be available and would be in the offender's best interest, and everybody agrees on it. Dale, do you have any comment on that, how that might work? Dale Crook, if you're here.
No, I'm here. I'm just looking for the buttons to click. This is really tricky language. I'm not really against it, but I'm kind of not sure this is where we want to land on some level. There's not, other than BEP and Crash are the only two that I know that have like maybe anger management that have set criteria. And I'm not even sure if it's set by duration or by, like Crash, you have to go through X number of sessions for substance abuse, and you have to do some other curriculum. So it might not be a set duration, but it's a set requirement to accomplish. Anger management might be a set number of sessions. I know batterers intervention programs is a set number of sessions. Most of BEP will be taken out because of B, because that will probably eliminate a lot of the domestic violence cases. Now, I guess the question I would pose to the committee is, there are a lot of programs that are based on behavior change of the offender, sex offender treatment, for example. So an offender will not be discharged from sex offender treatment until they have made certain behavioral modifications and they're applying the skills they've learned to daily life. I don't know how you account for that. If it's a committee's, that's just one example. Mental health is probably the same. Substance abuse is probably the same, where it's really based on, the ending is based on the probationer's change, rehabilitative process. So I think that's the tricky part for me. I would not want to be put, like, how I would read this language right now is there could be an offender in one of those, let's say a sex offender program, is showing up and is compliant, but is far from modifying his behaviors. They're not in violation. We would be required to submit a discharge. Now that may or may not get caught farther upstream by the court. So I think that's the trickiness with this that we're trying to figure out. And if it's just that they are in compliance without completing those types of programs, then we can do that. I mean, that's not the issue, I guess.
What about on page 2, the probationers not substantially in compliance with the conditions of probation that are related to the probationer's rehabilitation and or to victim or community safety? Wouldn't that cover that concern?
That would be on the court's end, so maybe Judge Gerson could chime in, but I would say that they are in compliance, and then it would have to be a determination by the court if by them not completing that program, would they put the victim or the community at risk. So I think that's the trick that the court would be looking at.
I'm reading them in, I think they're intended to be, aren't they intended to be in concert or in jive with each other, David? That's the wrong
Yes,
word.
they
I
are.
know, but they're,
And the other thing I'd point out is a lot of those, my read, unless I'm misremembering what the statutory sections are included in subdivision B. Subdivision B carves out a lot of those offenses, like the sex offender offenses, which I actually think is a reasonable policy decision, because it does remove some of these questions about programming, trying to define programming. Just saying, look, for those serious offenses, including the sex offender offenses and the programming that might result for that, that's not going to be a automatic, required discharge recommendation, because it's carved out under subdivision B.
Matt, did you have a comment on this?
I think I was going to say exactly what Dave Scher just said, which is I believe every instance that Dale Crook talked about was carved out in sub B, because that's the domestics listed crimes, sex offenses.
It would also include the department's risk reduction programs. It would also include mental health treatment. It would include substance where there's not where the ending of the program is based on the change in behavior of the probationer. And that's, we can, I'm not pushing either way. I'm just saying that's how I would read this right now. So if someone is in one of these programs, substance abuse treatment, and they're still struggling, but not to the point of violation, and they're showing up, we would still submit the discharge. And which is fine if that's what the committee is looking for. I'm just trying to, I'm just trying to give a picture of how we would apply this at the department and for the probation.
Senator Sears?
Yes, Senator White.
I understand that, Dale, but doesn't substance abuse, doesn't addiction imply that you struggle all your life? I mean, I thought that, how would you ever say that this person has changed their behavior to the point where it's acceptable to, I don't get that. Then the same thing with mental health issues, that somebody who has a recurring mental health problem that's triggered by certain things, how would you ever determine that they've changed enough that they would qualify here? I don't.
It wouldn't be the probation officer, it'd be the conversation with the treatment provider. Like for substance abuse, they'll have intensive outpatients and then they have aftercare. So the intensive outpatient is when an individual is really struggling. They may be on MAT or other treatment. They're going multiple times a week. They make progress. They have clean UAs through the program, and then they get to a step down. That is a breaking point, and that aftercare could continue with them for life. But the intensive outpatient is for a shorter period of time, and they don't get moved down until there's certain indicators that the offender does. Same with mental health treatment. You can have more intensive, and then you can have an aftercare.
So once someone was done with whatever the intensive program is, they would be considered substantially in compliance.
I'm actually going to be in complete agreement with Senator White there. I worry about terms like compliance or substantial compliance, because it might indicate, did the person successfully complete the program, or didn't they successfully complete the program? And that is such a difficult thing to figure out. The better the con artist, probably the more likely it is that they completed it in some cases.
Yeah.
And I worry about in some districts having one set of rules and in another district having another set of rules. So I really worry about that. I mean, we can lead a horse to water. That's what crash is, but it's no guarantee that they're going to stop drinking. So that's why we set it up. I believe that the original crash philosophy was, we don't care if you stop drinking. We just don't want you to drink and drive. And or drug and drive now. But that was the original philosophy behind crash. So how do we get people to take responsibility for not drinking and driving? That's my example. And if the crash program wants them to stop drinking completely, that may be a great goal, but they may not accomplish that. Am I making any sense?
Yes.
So it's how we thread this in the language. Judge, can you help us?
Well, I don't know if I can help. I can probably complicate it. When I'm listening to Dale and listening to Senator White, but when we talk about substance abuse or mental health issues, we're not expecting that it is a lifelong issue. But what we're looking for usually, and I'm analogizing it to treatment court, when people graduate from treatment court, it's not that they're in compliance with the treatment program. They will continue to have to address that for the rest of their lives. But they graduate because they have satisfied us. I assume the same way they would have to satisfy corrections, that they're in compliance with a treatment program. I guess that's the way I would respond to the issue raised by Senator White. Otherwise, you'd be keeping people on forever, and that's not what I think we're trying to do. My concerns go in a little different direction. I look at the last section, I guess it's section 3, where the department is apparently going to make a motion to discharge someone, reading this language, has completed any rehabilitative or risk reduction programs, and so forth. But then we go back up to section 2, where it's now before us. They've made the motion based on that. They have indicated that the person has completed And then we're asked to determine whether or not they're substantially in compliance with the conditions of probation related to rehabilitation. That's if the state opposes the discharge. So then I guess we're being asked to decide whether the department is correct in their assertion that the person has completed. And I don't know if we're just looking at that specific language in section 3 that talks about rehabilitation programs that of a set duration, or are we distinguishing that by the time it comes to us? So I'm a little concerned about the reference on the department's end that they have said this person has completed, and then we're being asked to determine whether they're in substantial compliance. That's one issue. The other one is in the additional language that David has added. It says that are related to the probationer's rehabilitation or to victim or community safety, which is the same thing we've just said in A. So I'm not sure why we repeat it again in B. I just, maybe David can explain that. The only other thing I would add that's not in the bill now, it just occurred to me as I was reading through it. We're starting with the idea that the department has made a determination to file a motion to discharge someone. We're putting the burden on the state to provide evidence why we should not discharge. I don't know if Pepper will agree or even Matt, but I think we need to have a time limit for the state to file that objection after the motion has been filed. These cases have a way of languishing, waiting just to find out, does the state agree or does the state oppose the discharge? And so I think in that preceding section B1, unless the prosecutor, and then you can insert whatever reasonable time, 10 days, 2 weeks, files an objection. Because I think it's important to trigger that. Otherwise, these have a way of sitting there, not knowing whether there's really going to be an objection. Whereas if we have a time limit and the state hasn't filed, then we can grant the discharge if we're so inclined. So I would ask the committee to at least think about that. But my primary concern is, on one level, the department has made a decision of complete compliance, and then we're asked essentially to perhaps revisit that and say, what is substantial compliance? I didn't say I would help. I said I might complicate things.
Well, no, Senator, sure. David, sure.
Thank you, Senator and Judge. Fair questions. Let me try to explain, if I can, what the intention was here. And again, happy to, if the committee finds that there's better language to capture that, that's great. The idea here on page 2, subdivision B, was that we've been talking a little bit about how there are some requirements of probation where there's, and perhaps it's not very many, which I actually think is fine, but there are some requirements of probation where there's a sort of set knowable program that you're done or you're not done. You're done with it or you're not done with it. But there are other requirements of probation that, as folks have been just talking about, could go on for life, dealing with addiction issues, trying to recover from those, drug treatment programs, things like that. And the notion here is that a probationer may have fulfilled the requirements of D1 down on pages 6. They've completed whatever set knowable programs have happened, but they are still engaged in other programming related to rehabilitation, addiction issues, whatever, mental health treatment, whatever it might be, but that's an ongoing project. And this provides a sort of safety blanket for the court to say, okay, you reached the halfway point. You didn't have any set programming that was defined in D1, so your discharge came up to the court. But the reality is, you really haven't been engaging in any of this stuff. There has not been a good faith effort here. We need you to keep doing what you need to do, and for that reason, we're going to continue probation. You know, states opposed it for that reason. We're going to continue probation for that reason. And the idea is that the courtroom is the better place to have that decision be made, because there can be a sort of hearing back and forth between the, not sort of a hearing, there can be a hearing back and forth between a defendant and a prosecutor, and the judge can make a decision about what's really going on. DOC, of course, could weigh in on behalf of the state as well to explain what's happening. And it provides an avenue and a safety blanket to say, all right, this is a person who does in fact need to continue on supervision because there's rehabilitative things that they are not engaging in. And we need them to do that, and we need supervision to continue. The other, the reason for saying rehabilitation or victim or community safety is that what we shouldn't be doing here is continuing probation for the sake of supervision. Like, supervision for supervision's sake isn't what we're trying to accomplish. And so I put those phrases in to say, like, hey, just because you may not have always answered the phone when you're supposed to, or made every appointment, as long as you're substantially in compliance with the conditions that matter. And I don't mean that the supervision doesn't matter at all. You need it to accomplish probation, but the sort of underlying societal goals that we have around victim safety, around rehabilitation, those are the reasons. If you're not complying with those are the reasons that we might need you to stay on probation. So trying to sort of carve out supervision for supervision's sake and say, let's really focus on the meat of what needs to be done here for rehabilitation. And I think it's true, you're right, that the victim safety piece is in there twice. I think that it could be seen as belt and suspenders, but I don't think it's entirely that. One is sort of the subdivision A at the top of page 2 is a forward-looking inquiry, and subdivision B is I would argue, a bit more of a backward-looking inquiry. You had these conditions related to victim safety. There are questions about whether you've been calling this person, for example, and we think, there's evidence to suggest that might have been happening. And so that's a reason that's going to inform, perhaps it's necessary to maintain supervision. Of course, that is also implicated in A. So I acknowledge that could be a little bit belt and suspenders type of approach, but that was the idea there, was I'm trying to carve out that, just supervision to keep supervision isn't what we're trying to do.
You're giving me nightmares.
Sorry, Senator.
No, you're talking about measuring something that is extremely difficult to measure. And I'm not sure that we could be here for a year talking about how to measure whether somebody has successfully completed or substantially in compliance, those types of terms. I envisioned, when we started this process, making sure that people had an opportunity, if they've done well on probation, at the midpoint of their probation term, they had an opportunity to be discharged. Because the record is way back, all the information is that people usually screw up in the first 6 or 7 months of probation. After that, they don't. And sometimes you overdo the requirements, and they have a small technical violation and it sets them back. So I hope we don't get too bogged down in whether or not they've complied. I want the midpoint review to mean something. It gives somebody something to work towards. Wow, I've got a 2-year probation sentence. I can get off in 1 year if I really put my mind to it and I work on these issues. I don't think we can make it perfect, because these are human beings, and some of them are going to still need more. And that's something that the judge, probation and parole, and the state and the defense are going to have to argue out in this midpoint review. But if 90% of the people who go for this midpoint review who've done well in the first year of a 2-year probation sentence, they get off probation, it may be that smaller number that we continue the argument about. So I don't have a problem with your language as long as we're not setting up probation and parole to be a long-term. I struggled with how to say somebody successfully completed the program I ran. And finally, I determined that the best way to do it was that they gotten all they can get. And then I felt like they put the effort in, we put the effort in, and they've gotten what they can get. It may not be perfect, but is there any point in continuing? Will that help? Continuing this person on probation, will it help? And as long as it doesn't impact community safety or the victim's safety, then they should be released at the midpoint. That's my view. That's what the goal of the bill is. And I think we've gotten into this debate that we can't solve.
Senator, I think you raise a very fair point, and I just say two things. One, I mean, that's the heart of the matter here is how to deal with those questions. And I think, point one is that's partly why I tried to confine those questions to the court so that you do have this opportunity for a hearing, and that the statute is constructed to put the burden on the state to show that these things are required in order to continue, so that hopefully with that burden being on the state to show that this is necessary, you are still going to be pushing people off probation, that the scale is weighted in the direction of getting people off of probation. So I think that's the idea here. Obviously in practice is going to make some differences. And the other thing I'd say, I'm not sure if I fully support this myself, but if the committee wanted to go down this road, you can narrow subdivision B on page 2 even more, or eliminate subdivision B. As soon as I say that, I'm sure there's going to be some opposition to that, but that would be one way of addressing some of your concerns and saying we're just going to focus on victim safety. So I throw that out as a policy.
Victim and community safety. If the person's no longer a risk to the victim or to the community. Judge Gerson.
Yeah, again, I'm not trying to complicate it, but having in mind, I see two different issues here: public safety, community safety, victim safety, and compliance with conditions of probation, rehabilitation conditions. Having in mind the department is going to make that determination to seek a discharge, and if I hear the chair and the committee wanting to encourage discharge, one approach may be to differentiate between the issues that are before the court. In other words, on the termination, Section A will present a risk of danger to victim or the community. Fine, make it preponderance of evidence. But if we're arguing about substantial compliance with these conditions, Section B, maybe the standard of the burden of proof should be higher on the state to continue them for that reason, and make it clear and convincing at that level for that portion of the that would seem to enhance the department's original decision. They're the one that's been working with this person. They're the one that's saying it should be discharged. And unless it's public safety, if we're talking about substantial compliance, then make the burden heavier on the state and make them respond, as I said, in a timely fashion so that we can move these cases. Just an idea.
No, I think that's getting us in the right direction, to be honest. Is there anybody else who has a comment on this that hasn't already commented? Dale?
We can apply this as a department, but and this may be the intent, there would be very little, if any, discretion from the probation officer. They'd be checking for non-compliance and for violations. Other than that, there could be minimal offender change, and we'd still be submitting a discharge, which if they haven't reoffended and they're not a risk to the public, I agree they should not be under probation for the sake of supervision. Only other thing I would ask is that the risk reduction programs be changed to risk reduction services. We have our departmental programs is called risk reduction programs, and I don't want that to be confusing for everyone. And I think services is a little bit broader. That would include things like AA or mental health or just other things other than treatment or programs per se.
Yeah, sounds like a good plan. Any other, Pepper, do you have any? I'm sorry, Senator White, and then I'll ask Senator Pepper. I mean, you're muted, Senator White. I'm sure it's been an important message for us, so you can
Yep.
repeat it.
It's
please.
actually Sergeant Pepper, not Senator Pepper.
Oh, Sergeant Pepper.
Anyway, sorry about that. But I just wanted to comment on what Dale just said about there might be minimal offender change. And while that might be true, unless the person presents a risk to public safety or victim safety, I'm not sure that change, we're asking people who are on probation to assure that they can be good, more so than we're asking those of us who are not on probation. And unless they present some kind of risk to public or victim safety, it seems to me that the changes in their lifestyle or their pattern of whatever it is not, should not be considered. I don't know, I did not say that very eloquently, but it does seem to me that the issue is the risk to public or victim safety, and that's what should be measured, not whether they've suddenly become a good person and changed their habits or their way of living.
No, Senator, I agree with that, and that was not the way I was trying to make the statement. With the way she is written, there's very little discretion for the probation officer.
Mhm.
If they're just checking the boxes, they could still be having the same issues, but we would still submit the discharge. And I do believe that there's a lot of evidence out there on dosage probation, and once rehabilitative programs are completed, that supervision, continuing of probation supervision, is ineffective and actually makes people worse. So I agree. I mean, I think the secret of everything we're trying to do is keep the individuals that we need to have under supervision or incarcerated where they belong, and have the ones that don't need our services or incarceration out. So I think that's where we're trying to get to, and I think this probably will help us move in that direction.
Sergeant Pepper.
Hey, thank you.
Sorry.
Just for the record, James Pepper, Department of State Attorneys and Sheriffs. I mean, this is a very tricky from a drafting standpoint. I absolutely agree. I'm actually of the opinion, which may be a minority here, that the current midpoint review process is working fairly well, but that making it more presumptive, making sure that those motions go to the court, and then the state's attorney, limiting the ability for the state's attorney to object to them, is what we're really looking to try to do, to make it more presumptive that people actually get discharged when they don't have, when the individual probationer doesn't pose a public safety or victim safety risk. So, I mean, this isn't a very helpful comment, but I think that, maybe we leave the language in the current midpoint review, but then make the motion more presumptive. But it seems to me that, I think that DOC is actually doing a decent job currently. I have one, I don't want to be overly tedious, but I do have one comment on the thereby word, the word thereby in the purpose section of the bill. I know that everyone seemed to be okay with using the term thereby protect public safety and victims in the community safety. It seems to me that by putting it thereby there, what the committee is saying is that public safety and community safety is a good byproduct of probation, but it's not one of the underlying purposes of probation. And, I think that when we have conditions that are specifically standard conditions of probation that are specifically related to public safety and victim safety, such as don't purchase or possess a firearm, or don't contact or harass the victim, I think it may when you look at the purpose section, may have a chilling effect on the court's willingness to use those either at the outset of sentencing or at this midpoint review. So I'm not a fan of the thereby, but I know that's kind of a secondary point to the conversation that we're having.
Senator Sears,
Yep.
I hate to say this, but are we not supposed to be in a joint session right now?
I thought it was 10:30.
Oh, it's 10:30? I
No.
thought it was,
10:30.
okay, thank you.
You're welcome.
I could go along with changing that thereby. I think. I know we changed it once, but.
Well, I mean, I'm reading now from the Pew study. States can shorten probation and protect public safety. And no national standard exists for how long probation should be for any given case. Rather, the findings of this and other research suggest that probation should only be long enough to meet its basic objectives of providing accountability proportional to the underlying criminal offense, connecting people to needed treatment and services, and enabling individuals to complete programs such as cognitive behavioral therapy and counseling that have been shown to reduce the risk of reoffending. Analysis of data from Oregon and South Carolina showed that among people who were on probation for a year without being arrested, more than 90% could have spent less time on supervision without an impact on recidivism as measured by rearrests. So that's the heart of this bill, really, is to look at ways we can reduce probation length without and still protect public safety. So I think when we get away from that goal, we just perpetuate the current system.
Senator, sorry.
No, I hear what you're saying, but I don't think the midpoint review is working as currently constructed.
Senator, if I may just briefly, I apologize to the committee. I do have to, I'm supposed to be in multiple places at once. And I just wanted to say, I completely agree with what you're saying, Senator Sears, in terms of the goal here. And I wanted to second Judge Grierson's idea about, it seemed like a reasonable middle of the road idea between eliminating subdivision B and keeping it and making sure that that is a higher bar to meet. Seems like a reasonable middle road to ensure the goals that you're talking about in terms of really weighting this towards midpoint reviews happen, they get to court, and they are mostly approved unless there's some really, either there's a good reason for to worry about victim or community safety, or there's a really good reason to worry about substantial compliance. So just wanted to put that out there, and thank you to the committee for consideration.
Very crazy. Mike.
What just happened?
Dick left the frame, I think.
I just left the frame. I'm getting out of the way of somebody who's mopping the floor.
Oh.
Sorry. Life goes on. This is Zoom life at home. Okay. My suggestion is that we take a look at the changes that Judge Grierson's recommended to David's proposal. And are people okay with that, or problems with raising the bar to clear and convincing in terms of completion of programming, etc. Leaving it as the other standard for station land. Preponderance of the evidence for the community safety and
Certainly have been back and forth with that. And the other day we decided, yes, final with regard to preponderance, and I wrote it in red. But no,
Yep.
I think, yeah, we definitely should consider what Judge Grierson has said.
Dale, Matt, or Pepper, any comment?
I think that will increase the discharge rate by having the higher standard. We have no objection as a department, though.
Chris Fenno, James Pepper, Matt Valerio, any comment?
I mean, to me, that satisfies my primary concern, so I don't think I have any problem with that.
Chris?
Chris Fenno, Vermont Center for Crime Victim Services. We have no problem with that now either.
I'm not concerned about the standard of proof particularly.
Right. Bryn, can you prepare that as a draft?
Yep, I can. And is the idea to make that change and then leave the other language as proposed by the Attorney General's office?
Yep, and I think take out thereby in the purpose section. Am I correct that that was the committee's desire?
Yes.
I kind of like thereby, but I'm fine if it goes.
Well, I thought you were the one that wanted thereby out. I thought I liked thereby as well.
No, it's of no real consequence, I don't think.
Well, you're the professor of English.
Yeah, I thought thereby was very stylish.
All right.
Maybe we could
Thereby,
put in a heretofore also,
Or forthwith.
or forthwith.
do we want thereby out or in?
Oh, give it to the leader of the Lonely Hearts Club band. Let him score one.
The goal for us mostly at these midpoint reviews is to eliminate all conditions except the ones that deal with victim safety. And so, but those aren't really rehabilitative conditions necessarily. So I don't want the court to think, well, that's not an appropriate use of probation.
Okay.
You mean protecting the safety?
Right.
Yeah, I agree.
All right, then take out thereby. Give them a victory.
I would just encourage the committee to consider putting in a time frame for the state to
Oh, I forgot.
Yeah.
put everybody on notice.
What's a good time frame?
10 days, 2 weeks.
That agreeable to the state?
That should be fine. And
When
I
we-
would just,
When we use the term 10 days, is that 10 business days? I've forgotten now.
So have I.
Remember, a day is a day, and Senator Benning reported the bill and had quite a poem. I remember him doing it, but now I don't remember what a day is anymore.
I think generally the construct in Vermont is that if it's less
That'd
than
be 2
10,
weeks.
it's business, and if it's over 10, it's calendar. So it's always good to say business or calendar, just to make it clear.
I would just point to the intersection of our response and our requirement of victim notification. But so 10 days / 2 weeks might be a little quick, but if we actually want to get substantial victim participation, but maybe there's a way to just draft that reasonable notice standard to say that it shall not interfere with our response, the state's response to the motion. The failure to actually hear back from a victim or something along those lines.
still think there should be a time frame of some kind. So many of these just come in and they sit there and sit there. And we really need to be on notice if we need to schedule a
1
hearing.
day should be plenty of time to reach a victim.
10 days? Is that what you're saying?
21, I think.
Oh, 21.
Gives them 7 days to contact the victim and still 2 weeks to file an objection. I mean, presumably you can contact somebody in 7 days.
You may want to indicate that they have 10 days once the state's attorney's office receives notification of the discharge. Because it could, we could file as a department, it could go to court, there could be time frames getting it to the state's attorney before they actually have their time frames. For the department, it's irrelevant. I'm just trying to be helpful.
But I assume, Dale, when you file a discharge, you file a copy not only with the court, obviously, but with the state's attorney.
It's different by courts.
Really?
Sometimes, I believe.
It shouldn't be, but
I agree.
you and I can talk about that.
I agree, and yes, we can.
Matt, 21 days?
Yes. Yeah, thank you. I've been trying to distill this down into what has been bugging me about this. And I think that in the course of the discussion today, I have probably hit upon something. And so what I did is I sent an email out to our listserv and asked a question. What I am concerned about is how probation interacts with poor people's problems. It's not the kind of problems that you and I have, but poor people have difficulty keeping residences. They have problems keeping jobs. They have problems getting around. They have problems taking care of their kids. And over the last couple of years, the Defender General's Office has had a lot of litigation and Supreme Court appeals regarding the conditions of probation to try to enable, to whittle down so that conditions of probation are only related to criminogenic risk and the like. And the statutes don't always reflect what the Supreme Court has basically said, or the conditions don't always reflect what the Supreme Court has said, which is you should only be putting in conditions of probation that are specifically related to this person's rehabilitation and risk to the public. And so we still end up, there is no such thing, according to the Supreme Court, as a standard condition of probation. Like that you live an orderly and industrious life, that you maintain a residence, that you maintain a job, that, those kind of things. But those are the things that tend to hang people up. And the longer they're on probation, it's almost an inevitability that they're going to end up being violated. So while everybody was talking, I sent out a thing to our listserv, and I asked, are you guys seeing any violations of probation for failure to maintain housing or jobs? And in less than 10 minutes, I got a couple of responses back that said, yes, we're seeing. I had a guy who lost his job during the pandemic, and he couldn't get a job for 5 months later, and VOP was filed. Now, I don't know the details behind all of that. There might be more to it. I got another one involving housing, where the housing went away, and so the client was couch surfing for a number of months and didn't have a stable place to live, but they weren't committing any new crimes. These are things that poor people do all the time. They don't have stable places to live all the time. They don't have stable jobs. They have difficulty taking care of their kids, that kind of thing. And to me, I know we're getting there with this, but it's not oftentimes burdens of proof that are going to tell the story here. It's going to be what the conditions are that people are held to while they're on probation. So I think this bill is another small step in the right direction to getting where we need to be. But I think the issue really is about how we look at poor people's problems. And you know, I have some apartment buildings in Rutland. I recently had a tenant in the front apartment who bad alcoholic, but he was a guy who worked 60 hours a week, but very bad alcoholic. He recently just died. And it was the alcoholism, the secondary of it is what caused it. But if you looked at him, if he was a guy who was on probation, he would be violated all over the place because of his substance use and his inability to get that under control. But he always had different apartments, but he wasn't committing crimes. And people make choices that aren't healthy for them. They're not good for society and the like in the general sense. But I don't think those are the people who should merit the ongoing supervision of the criminal justice system. And that's.
I appreciate that. I don't know how to solve it in this bill at this point.
Yeah, I think we're getting there. But I almost think it is the people I talk to higher up in the Department of Corrections agree with everything I just said. How that filters down into the training of COs and the like, and probation officers is, another thing, I guess.
Senator Sears, I've got to cut out because I'm making a nominating speech in our next event.
Yeah, well.
Me too.
Well, okay. We're going to end it then. I was hoping that we have come to a pretty close agreement that we could take care of on this bill tomorrow morning. If we can squeeze it in tomorrow morning, Peggy. I'm not going to be here until about 10:30. I'm taking my wife for a COVID shot.